Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And today's video is another in our series entitled Real Estate Fundamentals You Should Know. And today's discussion is a most fundamental issue. Every real estate broker has to deal with the Seller's Disclosure Act in virtually every single transaction. And the question that I get most often with respect to the Seller's Disclosure Act is my seller exempt? And then I get whatever set of circumstances are plaguing this particular seller. And the question almost invariably is no, your seller is not exempt. Because the sellers who are exempt can be narrowed down to very specific categories. Here goes. You can actually read the statute if you want to find the exemption language. It's at RCW 64.06, and you can look at the exemptions. I'm going to nutshell this information for you because there are a few more exemptions that I'm going to tell you about, but most of you are never, ever going to encounter the bulk of the exemptions in your in your real estate career. So the ones that you're going to encounter, those are the ones I'm going to tell you about today. You're going to encounter property that's owned by the estate of a deceased person. That transaction is exempt from the Seller's Disclosure Act. But only if title to the property is held by, quote, the estate of John Doe. If the title to the property is held by the living trust of John Doe, or Jane Doe as the power of attorney for John Doe, those sellers aren't exempt. The only seller that's exempt in this category is the seller whose name on the preliminary commitment for title. So if you haven't pulled the preliminary commitment for title, I don't know how you answer this question, but if the seller's name on the preliminary commitment for title is, quote, the estate of, then the name of the deceased person, then your transaction is exempt. But if your seller, if the seller is equally deceased, but their property is not, but the property that they used to own is not in an estate and instead it's in a trust, they're not exempt. If they're not yet deceased, but they simply lack capacity, and so they have a guardian or a power of attorney signing on their behalf, they're not exempt. And it's irrelevant whether the person signing the purchase and sale agreement has ever even seen the house, much less has familiarity with the condition of the property. That seller is not exempt. So, first category of exemption that you are likely to encounter is the estate of the deceased person. If the title to the property based on the preliminary commitment for title shows title in the estate of, that seller is in fact exempt. Also exempt, sellers who are selling a condominium and are required to provide a public offering statement. Might be a brand new condominium, it might be a conversion condominium. If the seller is required to provide a public offering statement, then they are not required to comply with the Seller's Disclosure Act. Please limit what I just said to my actual words. Only if the seller is required to provide a public offering statement are they not required to provide a seller's disclosure statement. That does not include any seller who is required to provide a resale certificate. Most condo sellers are not sellers of new construction. So any seller of a condominium that's a resale condominium is going to be required to provide a resale certificate. Those sellers are not exempt from the Seller's Disclosure Act. Said differently, the seller who provides a resale certificate is also required to provide the seller's disclosure statement. That's it. Those are the categories. Let's talk about some of the categories of sellers who are not exempt. We've already mentioned some of them. Powers of attorney are not exempt. Guardianships are not exempt. Trusts are not exempt. Don't confuse yourself if you read the statute with the fact that a bankruptcy trustee is exempt. The bankruptcy trustee is exempt, but the trustee of a trust is not exempt. Property that was where title was taken by the current seller through a foreclosure process, those sellers are not exempt, even if the seller is the bank that took title to the property through a foreclosure process. Again, don't confuse yourself if you read the actual statutory language. The statutory language talks about a foreclosure process being exempt from the Seller's Disclosure Act. That's the actual foreclosure process itself, where the property sold on the courthouse steps, the gavel goes down, is there a higher bidder, yada, yada. In that scenario, no Form 17 or no Seller's Disclosure Statement is required, because obviously the person who's losing title is probably not going to provide a disclosure statement. But when the person who gains title through that process, whether it's a bidder at the auction or a bank, whoever takes title at the end of that foreclosure, then resells the property, no exemption. New construction, no exemption. However, if a new construction builder sells property, they are required to provide a Form 17 on that new construction residential property, but that builder is exempt from completion of sections 4 and 5 within the Form 17. The builder still has to provide the Form 17, but they are exempt from provisions of sections 4 and 5 within the Form 17. You don't have to remember this. Form 17 says it right on its face. New construction is not required to complete the sections 4 and 5 on the Form 17. So don't worry about remembering which sections, just remember in the back of your mind that there is an exemption related to contractors, but it's only with respect to the provisions identified on the face of the Form 17. The final issue I want to discuss with respect to the Seller's Disclosure Act and exemptions isn't really dealing with exemptions at all, but it deals with waiver instead. Often I get the question of, can seller require a buyer to waive the right to receive the Form 17, and if so, how? Sellers can always require a buyer to waive the right to receive the Form 17 and to waive the right to terminate the agreement based on the Seller's Disclosure Act if and only if all of seller's answers to all of the questions in the environmental section of the Seller's Disclosure Statement should be answered no, don't know, or NA. Let me say it differently. If any of the questions in the environmental section should be answered yes, then seller cannot require buyer to waive the right to receive the Seller's Disclosure Act or the right to terminate the transaction based on the Seller's Disclosure Statement unless seller has given to buyer the answer to all of the questions in the environmental section. Best way to proceed, listing brokers, if you have a seller who wants to require the buyer to waive the right to receive the Seller's Disclosure Statement, is for you to give the seller the forms, whichever version of Form 17 it is that they're supposed to be using. Ask the seller to answer all of the questions in the environmental section only. If all of those answers are either no, don't know, or NA, then that seller can require their buyer to waive the right to receive the Seller's Disclosure Statement and the right to terminate the agreement based on the Seller's Disclosure Act. If the answer to any of those environmental questions is yes, then the answer to all of those environmental section questions must be delivered to buyer, and then buyer can waive the right to receive the answer to the rest of the questions and the right to terminate the purchase and sale agreement based on the Seller's Disclosure Act. Oftentimes brokers get confused with respect to the exemption. Let's talk about the exemption for the estate, for example, and the right of a seller to require the buyer to waive, or the ability, I should say, of a seller to require the buyer to waive the right to receive the Seller's Disclosure Statement. If a seller is categorically exempt because they're either the estate or they are a new construction condo seller who has to provide a public offering statement. So if they're exempt, then they don't ever have to fill out the environmental section of the Seller's Disclosure Statement. An exemption is different from the seller seeking waiver from their buyer. So if they're exempt, they never even look at a Form 17, the seller. If they are not exempt, but they don't want to fill out the Form 17 for whatever reason, and they want to require their buyer to waive, they still need to answer the questions in the environmental section. Listing broker, you still need to review those, and if any of those answers are yes, then all of the answers to all of those environmental section questions must be delivered to buyer before buyer is asked to waive the right to receive the remaining answers to the remaining questions. If a buyer is going to waive their right to receive the answers to the remaining questions, the best way to do that is by having buyer sign that last buyer signature line on the last page of the seller's disclosure statement. Seller's disclosure statement is a huge topic. We've taken one small issue related to exemptions and incidentally waiver of the seller's disclosure statement. If you have just questions on this small discussion related to the Seller's Disclosure Act or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.